Hi everyone, this is Coach Jack of Longhorn Financial LLC. I hope you're having a great day and would like to welcome you to this episode of the Personal Finance Playbook. Today we're going to be talking about an issue that just about all of us need to think about, but for various reasons many of us don't want to. As people who care about our families, we owe it to our loved ones to be able to answer these types of questions, such as, what do I want to have happen in case something happens to me? How will I take care of my family if something happens? And how do I want others to remember me if I'm gone? Of course, these topics all involve estate planning. Now, many people think that whenever you say estate planning, people tend to think of the rich, but that's really not the case. We all need to make sure that what we want to have happen will happen. Joining me today is my special guest, attorney Suzanne Frechette of Lowell, to discuss estate planning for regular people. Welcome to the show, Suzanne.
Thank you, Jack. I'm really happy to be here today.
Thanks so much for your time. So let's get right into it. So let's talk about just the most basic of documents when it comes to estate planning. Let's talk about a will. What is it?
A will is the written expression of a person's wishes for the disposition of their assets after they're gone. So in layman's terms, it's what you want to see happen to your stuff after you die.
Okay, so to your stuff. So does everyone need a will? Like who needs a will? You know, maybe some circumstances of who needs one or maybe who doesn't need one. Can you just talk a little bit about that?
Sure. The easiest one is who might not need a will. Well, if you're young, in your 20s, living in an apartment, and really all you own is your personal stuff in your apartment, you know, furniture, personal items, you really don't need a will. You want to express to your parents, you know, this is my stuff, this is my, if I have particular items, my car, this is what I'd like to have happen to it. But for the most part, you have no real tangible assets that you're going to be transferring to someone else. The alternate would be an elder person who has already done their estate planning, pretty much gotten rid of their assets, or they don't have a lot of money in a rental apartment, and they've already expressed to their children, I want you to just take care of it. They've gotten their burial set up and whatnot, so perhaps they don't need a will. In between there is pretty much everyone else, and that would be you have a home, you have personal items, you have a car, you have bank accounts. You don't have to be wealthy, you just have items, personal tangible items that you want to make sure go to whom you want to go to. And you want to make it easier for your family after you go. Okay,
so what you're really talking about is when you say personal items, but really not necessarily just any everyday household items, but really anything that might carry some sentimental value or actual value, right? Mm-hmm. So like if there's a collection or an old, you know, like I know some folks collect like those commemorative spoons or something. You know, if that really means a lot to you, but you can, through a will, you can stipulate perhaps like who gets that instead of just your regular like who inherits my pots and pans, which you know really don't carry any value.
Right, and that's exactly right. Remember, value has different meanings to different people. There is the cash value, if you will. They have their antiques, or you have cars, or you collect record albums, and there's a tangible value to that asset, which you might want to go to a certain person. But then there's those items. There's your grandmother's bureau. There's maybe your wedding rings, earrings someone gave you, a brooch, or things that you really want to go to a specific person. You don't even have to do any of that. There's also the quick and simple will, which goes, you know, that everyone's going in equal shares to so-and-so, and everyone's going to split this and that, and it's very much broader. But certainly you have the option to add. Usually what we do now is we do the will, and then there's an MOU or a list that can be updated to the will without having to change the will.
Okay, and just for clarification, just to make sure everybody understands, so MOU is?
It's a memorandum of understanding. Basically, in simple terms, it's a list. I just did a will, and I did it literally on a spreadsheet, and you know, it's subject to change, and she can reattach it, we'll initial it, but we don't have to modify the will to say, you know, niece Joe gets my car. Now it's attached on the list, and the whole will itself is complete and doesn't have to be changed.
Okay, so when you do that, it just makes making changes easier in some way, right, for that type of situation. Okay.
Right.
So I know you talked a little bit about sort of what a will does, and thank you for that. But let's talk about sort of the opposite situation of sort of what happens if someone doesn't have a will when they pass away, and sort of what is this probate thing, right, that gets tossed around estate planning circles? Sort of what is it? Because I'm sure a lot of people, it's kind of a technical term. A lot of people may not understand.
So let's go back for a moment and talk about the other things that a will does so we can explain what happens when you don't have one.
Okay.
So one of the biggest things that a will does is it allows you to appoint a personal representative. We used to call them executors, but in 2012 that terminology changed. And so that's the person who's going to pay your bills. The tax man always comes due, so he pays your real estate taxes, your income taxes. It's going to pay for your funeral. He's going to make sure that the disposition of your assets within the will takes place. You're going to probably, if you have young children, have a stipulation about guardianship. That's going to take place a little differently because children are subject to what's in the best interest, but nonetheless the executor or the personal representative takes care of that. So that is really important to make sure that you have someone named, and you will typically have a backup person. So that is one of the things that the will does. Now, conversely, you don't have a will. For many reasons, people don't have wills. Mm-hmm. Even Prince apparently did not have a will, which led a
I
hot
think that's
mess.
right.
Right? $500 million, no will. So now he has 4 half-siblings that will inherit all of it. Some perhaps he has never seen in years. So typically what happens when you don't have a will is that someone steps up, and either the court will appoint based upon your brother said, I'm willing to be the administrator, or they'll appoint one, perhaps an attorney, someone who's willing to do that. Mm-hmm. The problem is they don't really know what you wanted. They don't know that you wanted your brooch to go to Cousin Mary or your wedding rings to go to your daughter, favorite daughter, what have you. All they know is there's an estate, needs to be taken care of. You are living in a home. Perhaps there's no one else on the deed. Got to take care of these things, make sure that they're all disposed of, because the law does not appreciate things that are kind of hanging there in limbo for years. They need to go somewhere, particularly land and property. So they're going to go by the law, and it goes by closest, nearest relative. That could be your sister in California that you haven't seen or talked to in 30 years.
Okay.
Could be, in Massachusetts, we're very liberal. We'll go back to second cousin, twice removed type of thing.
Wow.
So you're going to go far out to see who's going to inherit. And that's probably, at that point, not what you wanted. You may have a favorite nonprofit, charity, football team, what have you, that you would have said, this is really what I want to happen. And it's not going to, because you, not having a will, did not get to speak from beyond and say, these are my wishes. So now, specifically in intestacy, which is when you don't have a will, the spouse will inherit half, and the children will split the other half.
Okay.
Okay? If there are no children, but there are other relatives, the spouse gets the first $200,000, if there is, and then they split the other half with the other relatives. And of course, if there are no relatives, the spouse gets everything. And if there are just these relatives, they split in equal shares. So it's complex, and there's an administrator who you may or may not have known, but they're going to be going through this process in a much more prolonged and painful fashion than if you had, in fact, done a will.
But what you're really saying, though, is that if you die without a will, you talked about how the law will look for closest relatives going sort of as far as they need to,
right.
but that's really, it may not be what you really intended.
Absolutely.
Right? If you really intended to leave your money or your home or whatever to a charity, but you don't have a will, then nobody really knows that unless you somehow told someone, and even then that may not really be enough if it's not written down in the will, right?
Correct. Now the other thing to remember when we talk about non-probate assets versus probate assets, in all of our lives, for most of us anyway, we have an ability to name a beneficiary, life insurance, IRAs, even your home can have a second name on the deed. When at all possible, in every case, name a beneficiary, because that will pass as quickly as that process is in place for your life insurance. Whatever, if they have you send in the certificate 60 days, 30 days, you're going to get it right away. Probate, at a minimum, is going to take 9 months, at a minimum.
Wow.
Whereas, and if you don't have a will, that can be a long time. And, realistically, 9 months is probably being generous. I've heard of people in 3-4 years in, waiting for the estate to finally settle. So if you have assets that allow you to name a beneficiary, and that can always be changed, they're going to say, oh, I'm getting the IRA, my mom, dad, brother, whatever, passed away. You get it, next thing you know, your check's in the mail. Insurance companies are the same way, very quick. So again, if you can put someone's name on something, it's a non-probate asset, it's It's going to be disposed of relatively quickly. Anything, if you don't have a will or you don't have the opportunity to name a beneficiary and it's through the will, it will take that much longer.
Okay. And during the probate process is when the court is trying to figure out
Right.
sort of the next of kin or the heirs or even creditors, right, who you may have owed money to
Right.
when you passed away,
Right.
right?
Right.
So let's talk a little bit about sort of heirs. Yeah, I think it's probably one of those terms that people think is relatively simple, right? Heirs, my kids, boom, done. What else is there to think about? But sometimes it really can be a little bit more complicated
Absolutely.
than that, right?
So first of all, your spouse is not your heir because they're not your blood heirs, right?
Right.
A spouse has a specific legal category. As I said, they get a third, or they get, if they can elect against the will. So there's a definition for that. Your heirs are your grandchildren, your children. In utero, a probate is 9 months, just in case there are some heirs waiting to arrive. So those can take. Adopted children count as full legal heirs. And then, of course, as I mentioned, it begins to kind of spread out from there. I always say you go up and then across. So you have no children. First, we go look at your parents.
Okay.
If they're alive, they're taking right away. If they're gone, then we go across to see if you have siblings. If they're alive, then they take. If they're not alive, we go down the next level. Did they have children? And we go from there. But we start with your parents if you have no children or grandchildren, or however, if you're, God knows how far they can go. But that's how that process works without a will. And with a will, it's whomever you name. And again, remember, you can do in a will, don't have to give to any of your family. It's your favorite charity. It's whatever causes are important to you, and it's your personal desires being expressed through your will after you're gone.
Okay, and that makes sense. So that really makes sense. I appreciate you explaining that. So you touched briefly upon sort of certain things that pass outside the will. So talk a little bit about sort of the designating beneficiaries. And so, for example, if I have a life insurance policy that I leave to my kids or my favorite charity, which takes precedent, the will or the beneficiary I designated on that life insurance policy? Which comes first?
The beneficiary always comes first because they're non-probate assets, and there's really no legal means for someone to elect against the life insurance. Having said that, of course, they could always allege you were not of sound mind, unduly coerced into signing over life insurance. That's probably going to be a stretch, but regardless, a beneficiary on something named comes first and doesn't pass by way of the will. Now, where there is the tricky part is bank accounts. We have those opportunities to say name, paid on death. They're called Totten trusts. However, if there are debts to the estate, those funds will be used to pay those debts. And only after the debts to the estate are paid can the balance of those bank accounts be given to the beneficiary.
It's interesting you say that. I mean, quite often I will hear from folks I've worked with or folks who come to me for questions about this type of thing, and they'll talk about having an account that should they pass away, they have 10,000, 20,000, whatever that number is in that account, so that should they pass away, their son or daughter can then be able to access the account and pay for funeral expenses, final expenses. But they don't name their son or daughter as a beneficiary or as a joint donor. So, and often in those cases, I hear that families get stuck, right? Because I would imagine that during probate, you can't really touch that stuff. Is that correct?
No, it's not correct because you're going to have an administrator or a personal representative whose role it is to touch that stuff. Their role is to pay your funeral expenses, file your taxes, pay your bills. Within a typical written will, your personal representative can sell your home, collect rents. I don't know what else you might have funds coming in for, but regardless, you may own a store or other realty, and they can then collect all of that for you. They're required to maintain your property, ensure that all of the your tenants have adequate heat and all of that. So they're able to access anything that is part of that probate estate to ensure that those things are happening. And typically, no one should be stuck if the estate is being probated through the process in the court. Because they can go back to the court. Again, this is why it can take long. For example, the house. Nobody wants the house. It wasn't left to anyone specifically. Perhaps it's paid off, perhaps it's not. The decision is made, we think we want to sell the house. So you go to the court and you say, we want to dispose of this asset. We're going to keep the cash. It's not going to be sent, given to the heirs immediately, but we all know that this is going to happen. We'd like to get it on the market. We'd like to get it prepared for sale. The personal representative can begin to do that. Now, of course, you want the family involved to get rid of or take any things in the home that they might want, but nonetheless, the personal representative is on to take care of those things. Now, I will caution you to say that it's a tough job. We'll talk a little bit about that. Perhaps we can talk a little bit about who's going to be your personal representative.
Yeah, and I would have to imagine it's a tough job. So let's shift gears for a moment, and we'll come back to the personal representative in a moment, but let's shift gears a little moment. So everybody thinks about estate planning, okay, so you need a will, but that's not the only document that even regular people need. So can you just take a moment, talk a little about sort of the other documents that come into play here?
Sure, so there's two other things I would always recommend. It's the durable power of attorney, and there's two types, right? There's, I'm going in the hospital, this could not go well for me, I'm going to name one for a short period of time. I was also thinking in the positive way, I'm going out of the country for 3 months, I'm traveling the world, and I'm going to have things that I need to have done here. So you name a power of attorney. You want someone who is fiscally savvy, in other words, good with money, who is able to pay your bills, is comfortable paying your bills, and comfortable acting on your behalf financially. And so you would do that for a temporary while incapacitated, we say. The second kind is I'm aging or I'm going to be permanently incapacitated down the line, ALS, or name some other type of thing. I'm going to name a power of attorney, and on the day that I determine it, it goes forward such as that. Now, the temporary one is going to be revoked when that situation is removed. You're out of the hospital, you're clearly doing well, you're back in the country, what have you, ready to go. Now, the other one is permanent. They're going to act on your behalf. Again, they're going to probably pay your income taxes that year, take care of your taxes, what have you. They're going to act on your behalf financially. And it's always important to have that. We never know what's going to happen. And those are our wishes while we're alive. So then the healthcare proxy you can do as part of your estate planning, and that allows that person to make decisions on your behalf for your medical conditions. And it's really important to have a conversation. What does that mean? I always joke with my daughter to say, leave me in a coma for a couple of weeks, don't pull the plug right away. But you can literally stipulate different reasons why you would want to be, a do not resuscitate or what have you. Have the conversation, because though you wish this to happen at that moment, is that person emotionally prepared? So I would suggest it's not always the same person that deals with your finances that deals with your health. Because some people can handle this, but they really can't make that decision. I need to have the feeding tube in or out. I don't want them on, life supports. It's a gut-wrenching decision.
Sure.
You want to make sure you have that conversation. These are my wishes. Are you able to take on this responsibility and do this for me?
So what you're saying is that you may, with these three documents, you may end up appointing multiple people, right? A different personal representative for the will, a power of attorney, and then someone to handle your healthcare proxy, right? They can be different people. Right,
and so also why they can be is your power of attorney, if it's as you're aging, they can be someone living out of state, can come in, not so far, not so close. Your healthcare proxy, however, it's a good idea to have someone in proximity to where you live, because this could be an emergency situation. And if you're relying on someone who's living in Florida, for example, that's not going to be very helpful to you. Right. And your administrator of your estate, that could be someone who agrees to come in and do the work. It's probably going to be better if they're here. However, it's such a long, drawn-out process. They could be someone further away. It just depends on the circumstances. But most likely for those things that are happening while you're still alive, aka the healthcare proxy and the power of attorney, you want someone who's close.
Okay, and that makes a lot of sense, because like you said, there could be some major medical decisions, such as like a do not resuscitate, so-called pull the plug, if you will, that really can be very difficult for people to make that decision in the heat of the moment, right? So these documents really kind of tell your family, friends, or whoever what your wishes are so they don't have to kind of struggle with that decision, right? Is that sort of what the part of the rationale here?
Absolutely. It's like going back to the will. Why do we do a will and probate? It gives that legal effect of the court. So you can sort of deflect. Hey, this is the will. It's probated. This is what mom or dad or Joe wanted. Not my fault. This is what they wanted. This is the healthcare proxy. I talked with mom, dad. They don't want to be on life supports. They really would prefer XYZ doesn't happen. We've talked about it. Now, I would suggest, and I have this in there, is that when decisions are made, such as life supports, either doing them or not doing them, you talk about it as a family. Have somewhat of a consensus, because it's difficult. If you can't, that's fine, and it's only advisory, but try to do that as a family. With your power of attorney, again, you're just making those day-to-day decisions to ensure that what's happening to mom and dad off to the side here, illness, what have you, that their lives are going on, their bills are being paid. They're not going to be foreclosed on because they didn't pay their property taxes. You're taking care of those things. And that, again, could be two very different people who have different capacities. And that's what I would suggest, evaluating that and making sure you have that conversation. This should not be a surprise to anyone when these events occur. Oh, guess what? You're going to be the personal representative. Do you choose to accept that? That kind of thing. It's much better to have the conversation, give them the opportunity to express their concerns about whether they can do it, what they really think should happen, and kind of get that all out in the open.
So we talked at the start of the show about sort of estate planning for regular people.
Right.
So all these issues you just talked about, like just making sure the mortgage is paid, while you're in the hospital, or while you're out of the country, or making medical decision. I mean, that doesn't just involve the rich. I mean, that
Absolutely.
could happen to you, me, to anybody, right? I mean, that really is an everybody issue.
It is, absolutely. And the thing is, too, it's a young person's issue in many cases. Now, that's the most difficult part. We have children in our 20s, my daughter's in her 30s. I don't expect anything to happen. I'm not going to have had that conversation. But if I have and I know where she stands, it's much better. And as we age, it's even more important, because then those things become more and more likely. So it is for everyone. Even if, as I said, you don't need to probate an estate, having a conversation with your loved one, your parent who's living in a nursing home, who doesn't have a lot left. However, let's have a conversation. What does this mean? What do you want? I will say it's a difficult situation, and the more that they can do, meaning the person passing on, to smooth that out, the better off they are.
Right, because I'm sure that, and I've seen my share of family fights, when it comes towards the end, and not even about the money. I've witnessed a number of situations where people have said, well, this is really what so-and-so wanted. This is, no, this is really what so-and-so wanted. No, they want to be buried over here. No, they want to be buried over here. And they just can't decide, and you end up arguing, and it just causes unbelievable amount of stress on people on top of a very stressful situation already.
Right, that's exactly right. I would say, I hear people say this all the time, I'm going to be dead, what do I care? Literally, like, I'm not going to be there to deal with it. True, absolutely, obviously. However, do you want to think that you have created a situation which divides your family in such a way that they never can repair it? I have at least two of my friends who have never recovered from administering an estate. One who thought he didn't get his fair share, and he's not talked to two of his siblings, and the other one who was the administrator or personal representative and has siblings not talking to her. Now, in both cases, there was a will, and there was hard feelings involved with that, which may or may not have changed. However, it did leave a bad feeling for all concerned, and it really split apart a family that might have been much closer prior to that happening. It's a tricky thing. You're not going to make everyone happy. There was always probably going to be someone who says, that's not right. But the more you can think about it in a thoughtful fashion and be fair, and at the same time have your wishes known, I think the better off you are.
So let's take a moment and talk about the personal representative.
Sure.
We've already talked about how you can have 3 different people. Obviously, you don't have to, right? But you could have up to 3 different people, one for each document. So Any tips in terms of, for regular folks out there who are thinking, well, who should I get for this, or who should be my power of attorney? Who should, I entrust with medical decisions? I think in most cases for married folks like myself, pretty much put it in the hands of the spouse.
Absolutely.
It's sort of the natural decision, right? But even then, that's not right. So just take a moment, talk a little bit about sort of maybe some things you may want to think about as you're thinking about who really should take on these roles.
So I would evaluate again, so personal representative, that is a time-consuming job. You can pay someone to do that. It can be an attorney, it can be an estate planner, it could be someone that you say to your spouse, if I pass, I'm going to name you. However, I think this might be something you might want to hire someone, or I'm going to name someone who we're going to pay to have this done because it's going to take a lot of time and it'll be easier on all concerned. But regardless, it is someone who is detail-oriented, who is not afraid to make the hard decisions, and who isn't afraid to kind of delve in, get the stuff done. Hire the realtor to sell the house if that's what's necessary. So that is your personal representative. There's a lot that goes on there. Oh, and the last thing I wanted to add before I forget, because this is so cool to me. How many of us are sitting on Facebook minding our own business and up pops something from someone who has passed away?
Sure, all
right?
the time.
Happy birthday to
right?
so-and-so. Oh my God, they died. So Facebook does not allow a family member to just close down a Facebook account unless you have it either in your power of attorney or in your will that you have the legal right to do that. So now there is a clause within the will that says all my social media, my email, and it goes really in depth to say this person, personal representative, has the right to close my account or turn it into a legacy, Facebook page. And that's, again, it's really important because, quite frankly, I find it disturbing when I see people who have passed.
Yeah, same here, absolutely. So just time for one last question here. So what's something that people really should think about when it comes to estate planning that isn't necessarily common knowledge or isn't necessarily something that people find on the internet? So just something a little bit different that maybe people don't know but really should know.
So I think what I would say is simply this, and you can get a will online. Life changes. People think, oh, whew, got that done off my list. You don't. You want to evaluate your life. If you get divorced, for example, divorce negates all bequests or what have you in the will, but that might have been your personal representative. What are you going to do differently? That's changing. So wills are not, they don't remain the same. They change. You need to be mindful of that. You have to keep up with that. And the other thing that really struck me recently, I was looking at the Globe and it had an announcement about a lawyer's office closing. Come get your files, it said. So what if you didn't see that? Where's your will? So keep it on track with your life. Any changes that occur, either you get rid of assets, you remarry, what have you, make sure you're making those changes to your will. And make sure you know where your lawyer is. If he's holding your will, he's still in business. You haven't talked to the guy in 30 years, you might want to check on that. We get to retire at some point in our lives. And trying to track that down. I've known people who have said it took us like 6 months to figure out where it is. Okay. So really important to remember, it's not done and over with that one time. It is something that should change with you as your life changes.
Excellent, thank you. And many thanks to my special guest, Suzanne Frechette, attorney at law out of Lowell. I hope you got some information that'll help you work on this issue for you and your loved ones. Join us next time when we tackle another topic out of the Personal Finance Playbook. Have a great day, everyone.